Officer Day, would you open my courtroom, please? Officer Day. Madam Clerk.
36, the state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Good morning, everyone.
Good morning.
Good morning.
We are on the record calling file number 08131258. The file is called Credit Acceptance Corporation versus Kiva Sailor. This matter is scheduled for hearing today at 10 o'clock on the defendant's objection to garnishment. It's now approximately 10:37, excuse me. What is your name? Ma'am? Yes.
I'm Kiva Sailor.
You are the moving party, ma'am. What is the basis of your objection to garnishment?
Well, okay. First is that, great morning, Judge. I never received any inquiry about it. And when I found out about it, because they garnished my taxes, I immediately called all the numbers that were given to me that were available for me to call and check on the case. And when I called the number for the credit acceptance place, I asked all the information I could possibly get, and everything that they were telling me, I didn't recall. I asked them what kind of place was this, and then the lady told me she wasn't really sure, but it sounded like a car loan place, auto loan place. I asked, can you give me that phone number? Can I find out what's going on? Are they even still in existence? So as much information I was able to get was that it was supposedly a loan way back in 2004, I believe. And so I asked, do you know what it's for? What kind of car? She just couldn't give me any information, but she did say that there was a, what's the person that you have sign for you? A co-signer. And then that was my grandmother's name. And I asked her, I said, I don't recall my grandmother ever, co-signed for anybody. She wouldn't co-sign for a bag of sugar for anybody. And so I said, I'm thinking either this is some type of fraud or whatever, but I just didn't understand why I was never notified about any of it. And so as it went on, it said now that the owing is $19,000, close to $20,000. And I said, but I still haven't been notified, zero correspondence from anybody ever on the matter. So as I was calling all the numbers, trying to find out, I called the IRS, I called the tax, I think it was a number for the tax place. I'm not really sure what they call that. And yeah, and I couldn't get enough information. Everything was sketchy, but she did say she saw a signature for me. I asked if she see a signature for the cosigner. She said, no, I don't see a signature. And then I asked, why would they wait so long to try to do anything? And so I asked, how did they get how were they able to say that I owe them that? And they said they were granted a win, if you will, because I failed to show up. I said, well, how can I show up for something I don't know exists? I said, well, whose job was it to make sure that I was called so that I could be there to contest? And she said it was theirs. I said, well, why would they make sure I'm there if they know they get the win if I don't show up? So I contested the whole thing. And even if I think I did recall anything about it, I just didn't understand why the amount would be what it is and why they wouldn't go after the cosigner.
Okay, let me give you a couple of things that you need to understand about the process.
Mm-hmm.
The court is before me is your objection to garnishment. Objections to garnishment are only limited to defects in or the invalidity of the garnishment proceeding itself. And under Michigan Court Rule 3.101K, you may not use the objection to garnishment to challenge the validity of the underlying judgment.
Right.
So you cannot say that there's something wrong with the underlying judgment in an objection to garnishment.
Yes.
Let me give you some information from the court's record on this file.
Yes.
The register of action indicates that you were personally served on August 4th of 2008, and the judgment by default was entered against you when you failed to answer on September 17th of 2008 in the amount of $7,476.32.
Yes.
That judgment was mailed out to you at the same Binder Street address that you are presently using.
Absolutely. And
Then-
it wasn't.
Then it appears that on December 20th, 2017, less than 10 years after the date of the garnish judgment being entered in September of '08, that
Mhm.
judgment was renewed. That was,
Mhm.
and a copy of that order was sent to you again on the Binder Street address.
Right.
So-
Except it wasn't.
In relationship to the garnishment itself,
Mhm.
the way the garnishment procedure works is that the party that has the judgment, in this case, credit acceptance,
Mhm.
they don't give you notice of the garnishment. What they do
Right.
instead is they give notice to garnishing defendant. The garnishing defendant is the person or entity that they believe has property or money that belongs to you.
I
It's
understand.
the obligation of the garnishing defendant, in this case, the Michigan Department of Treasury,
Right.
to notify you that you have been garnished, not the obligation of the plaintiff.
Understood.
In regard to the difference between the judgment that was entered and the amount that's presently claimed,
Yes.
in September of '08, the judgment, this would be a judgment on a written instrument, would bear interest rate.
Right.
At whatever the interest rate was stated on the loan,
Yes.
12%, whichever was the lower number.
Mhm.
Look at a 12% rate. That means that interest rate, we're taking over 12%, 6 years. The amount doubles just by there under the rule of 72. So
Yes.
that judgment would have doubled in that amount.
Mhm.
So basically, that's where we are at this point in time.
Okay.
You cannot use the objection to garnishment form to challenge the validity of the underlying judgment. And so the court is going to have to deny your objection to garnishment. You
Okay.
have an absolute right to appeal my decision.
Okay.
Effectively 21 days of today. Yes, ma'am.
Okay. Okay. So I understood that as I was reading it, but those are some things that were just obvious, the case for me. But when they told me what my options were in order to protest this, it was about it being served incorrectly.
Well, ma'am,
So-
if you want to file a motion attacking the underlying judgment, you have a right to do that. But that's not what you filed. What
Right,
you
okay.
filed is an objection to garnishment. An objection to
Okay. I
garnishment
thought
is limited to the claim of defect in or invalidity of the garnishment proceeding itself. As I
Uh-huh.
indicated to you earlier, the court rule specifically provides you cannot use the objection to garnishment to challenge the validity of the underlying judgment.
Right. Okay. But so only for them, not for me, not, it was issued under false information. That's what I'm saying.
Again, ma'am, if you want to file a motion attacking the underlying judgment, you can do that. But
Okay.
you cannot attack the underlying judgment by an objection to garnishment. And that's the only matter that's before the court.
Okay. So where this letter F, where it says the writ was not properly issued, that's not what I'm signing under?
Ma'am, I can't give you legal advice. What I'm saying to you is that the procedure for the writ of garnishment, which is a matter before me, the court rule specifically prohibits you from using the objection to garnishment to challenge the validity of the underlying judgment. And that's
Okay.
what you're trying to do. You can't do
Okay.
that.
Okay. I was just trying to understand clearly because it says I object to the writ of garnishment that was issued based on, and they gave me the option F, the writ was not properly issued.
Yeah, that is a attack on the underlying judgment, which is specifically prohibited by the court.
Okay, one more time.
That Michigan Court Rule 3.101K provides a pertinent part, and I'm basically paraphrasing. Objections may only be based on defects in or the invalidity of the garnishment proceeding itself and may not be used to challenge the validity of the underlying judgment. Okay, so court will deny your motion. You have 21 days from the day. We'll send out an order to you on that Binder Street address denying your objection. Thank you for coming in, ma'am. Have a nice day.
Thank you so much, Judge. You too.
We are off the record.
Thank you.
All right. Day, May 19.
Good morning.
Morning, Mr. Weberman. What file are you here on?
I believe I have two HS Financial Lanier and HS First Washington.
Uh, What is your name? Where did she go? Huh. I had somebody else a minute ago. She went away. Okay, so you've got 19975 and 20609. All right, here's somebody.
Uh,
Let's see who this is. All right, what is your name, ma'am?
This is actually her fiance. She's in the emergency room right now.
Well, first of all, what is her name?
Sandra Anglin.
And you're obviously not her.
I'm her fiance now.
All right, well, we'll have to wait till the other attorney comes on that case. But you're obviously,
Okay.
you're not an attorney. Oh, let me ask you, are you an attorney licensed to practice law in the state of Michigan?
No.
All right. All right, then I'm going to put you in my waiting room. We'll see if the other
Okay.
attorney appears.
Okay.
And with you, Mr. Weberman,
on one of them, I have proof of service. On the other one, I believe we had sent in a request to have substitute service.
okay, well, here's the situation. You have a motion for adjournment on the George Washington case. Is that the one where you did not make your service?
Correct. Yes, I believe they sent in the motion for adjournment and for substitute service.
All right, well, here's the situation. I will grant you an adjournment, but I'm not going to do substituted service because I'm not going to put someone potentially in jail without personal service.
Correct. All right.
And that's the problem with substituted service on this thing. So,
All right, Your Honor. Yeah, so I'm sure I'll tell my office and hopefully we'll be able to find their new address because I believe the process server said that they moved. So,
okay, so what I'll do is I will adjourn that date. Let me get my calendar out here. Oh. Today is May 19th.
correct.
I'll adjourn that date to July 14th. July 14th at 11 o'clock.
All right. And then should we or will we get a new notice in the mail that we can just attach to the subpoena, or should we just cross them?
What I'll do is I will go forward with your notice of adjournment, which was part of your motion. Okay.
All right. Yeah, that's fine. Yeah, I just hadn't looked at it because my office did it. So I was looking at it now.
July 14th,
All right. Adjourn to
11 a.m.
All right. So I will have keep an eye out for the entered order.
That'll come out. And the substituted service will be denied because ultimately what you're going to ask me to do is issue a bench warrant for somebody, and I'm not going to do that on a civil debt without public personal service.
That's understanding. I don't know why my office sometimes does substitute service on these, because even if we get them, then we never get a bench warrant, so it's just a waste of our time and your time. So I don't know why they send it in.
I couldn't agree with you more. I don't understand that at all.
Yeah, it's above my pay grade. So.
Okay, I understand. So you'll get two orders. There'll be an order in relationship to the adjournment, July 14th at 11 o'clock.
All right, so then just wait around for the other one, because the other one we did have personal service, so I don't know what time it is, so it's only 11:04. So
Yeah, let's wait around, see if somebody else comes on that one. But what I typically do on those, since you didn't make service, I'll just go ahead and I'll just dismiss that so you don't have to stay around. So first is, let me finish the paperwork denying the motion for substituted service. Okay.
All right.
And that's on the Washington letter. And your second file is the Macomb County versus,
no, it's HS versus Shante Lanier.
that's going to be 975. And that's the one where you didn't get service.
Yeah, that's when we did get personal service.
I'm sorry? You
Yeah,
did.
and that one we did get personal service.
Okay, then what I'll do is I'll hold this one and then we'll move forward at 10:30. Well, I guess it'll be 11:31 because I have to get an individual time to appear.
All right, that's fine. So I'll just mute myself.
Put you into the waiting room.
All right, thank you.
Okay, here she is right here.
Okay. All right. You are Sandra Anglin.
Hi, how are you?
Good morning. I don't have the other side as of yet. So I'll put you in the waiting room. And then when I get the other side, I'll bring you out. Okay.
Okay. Can you hear me?
She said, okay.
Okay.
I can hear you.
Sean.
Hi.
All right. We
Oh,
are
I said hi.
we are on the record calling file number 191749113. The file is entitled Macomb Community College versus Sandra Angle. What is your name, ma'am?
Sandra England.
The record should reflect this matter set for debtor's examination today at 11 o'clock. It is now 11:31. The defendant has appeared. The plaintiff has failed to appear. Therefore, the court will dismiss the debtor's examination, quash the subpoena issued for today. Thank you, ma'am.
Thank you.
Have a good day.
Okay.
We're all
Bye.
bye. Have a good day. Yes, ma'am.
Okay. You have a blessed one.
Thank you.
Bye.
We are on the record calling file number 191777975 HS Financial Group versus Shante Lanier. This matter is set for debtor's examination today, May 19th at 11 o'clock. It's now 11:32. Could I have your appearance, sir?
Daniel Weberman, P76609, on behalf of the plaintiff.
Sir, were you able to serve the defendant, Ms. Lanier, with the subpoena for today's hearing?
Yes, she was personally served on April 12th.
Okay. That doesn't seem to have made my file, so send me another copy. What is, sir, the present, I accept your representation as an officer report that she was in fact served. Oh, I'm sorry, I see it right here, yes. But it looks like, looking at the proof of service, it said the date and time was July.
Maybe you're looking at a previous one, potentially.
Oh, from 2020. Yeah, I don't see the one from today.
I can make sure that with a show cause that it's included. I know sometimes we send them in and they don't necessarily get there in time.
This is from 2020. What is, sir, the date, the outstanding, or is there an outstanding balance on your judgment?
Yes, we haven't received any funds. The current judgment was 2,763.
2763. Our defendant has been served with a subpoena and has failed to appear. No good cause of that failure having been shown. Bench warrant will issue in this matter. Bond on arrest will be $2,700. I look forward to your bench request, warrant request, sir.
Thank you, Your Honor.
Have a good day.
You too.
Thank you. The last file we are calling is file number 2015063, Harrison Financial versus Ivy Fleming. This matter is scheduled for debtor's examination today, May 19th, 2021 at 11 o'clock. It's now 11:44. Neither party has appeared. The subpoena issued in this matter will, excuse me, the debtor's examination in this matter will be dismissed, neither party having appeared. We are off the record.